In Burks versus Kaiser, the court struck a big blow to Kaiser Foundation Health Care's ability to force its customers to arbitrate their disputes. This issue is not only going to have an effect on Kaiser, but it's also going to affect any other health care service plans who are relying on arbitration clauses to keep them out of court with their patients. Both plaintiffs' counsel and defense counsel need to take note of this case and apply its lessons. The key issue here is whether Kaiser's enrollment form for its health care plan prominently displayed its mandatory arbitration provision as is required by the California Health Safety Code section 1363.1b. Now, this code section makes arbitration clauses ineffective in health care service plan cases unless the arbitration clause complies with a number of requirements, one of which is that the clause be, quote, prominently displayed, end quote. Now, the problem is the statute doesn't define what prominently displayed actually means. So, in this opinion, the court explains the meaning of prominently displayed for purposes of the statute and also explains why Kaiser's enrollment form didn't work. Essentially, Kaiser's form shows us what not to do with a mandatory arbitration provision in an enrollment form for a health care plan. Now, Kaiser's enrollment form consisted of a one-page document containing a large outlined box with text inside. The arbitration provision was located below the bottom border of the box, just above the subscriber's signature line. Now, the arbitration provision here didn't have a heading. It didn't use any font tricks such as larger typeface, highlighting, bold lettering, italics, or anything like that to draw any kind of attention to the paragraph. Now, Kaiser argued that the provision was prominent anyway, simply because it was located immediately above that signature line. Well, the court disagreed. The court said because the statute already contained a separate requirement that an arbitration provision be displayed immediately before the signature line, its location couldn't give it the prominence required by the statute. Otherwise, the prominence requirement would have no effect at all. The court stated that since the statute contained the prominent display requirement and the location requirement, something other than the placement of the disclosure would be needed in order to achieve the required prominence. Well, the only other feature that Kaiser could point to try to establish that the arbitration provision was prominent was its placement just below the outlined box. However, the court said that the provision's placement below that box did little, if anything, to make the disclosure stand out from its surroundings. It just didn't do the trick. So if you have a claim against a health care plan, look at that enrollment form. You may not be required to arbitrate your dispute. And if you represent health care plans, well, you better have a look at your clients' enrollment forms and make sure that they've done it right.